I'll also show to you.
Contract about?
Yes, well, so this was to operate, like I mentioned to your lordships, is something called the Gati Shakti Modal Cargo Terminal. So, it's a long 35-year bid. We construct the terminal, etc., and charge people who are using that terminal money.
Terminal access fees.
Terminal access fees.
Contract matters.
No,
is very less.
Yeah, before your lordships take a
five. A glaring question.
I'll show your lordship the glaring question.
Come straight away, tell us what.
I'm telling your lordship straight away that, and just bear with me for 1 minute and then I'll come. My technical bid was rejected. I was not given any reasons for rejection. The reasons for rejection were provided to me for the first time when the file was produced before the division bench of the High Court. Not before the single judge, before the division bench of the High Court. So, my lord, I got to know the reasons of my rejection then, and now I will deal with each of those reasons because now we have obviously got it. So, we filed it before your lordship.
So, why was it rejected?
Yes, it was rejected on 3 or 4 grounds. Would your lordships kindly do me, my lord, indulge me by opening, my lord, I'll just, my lord, kindly come to page 200 and, in fact, my lord, may I just show to your lordships 2 clauses and then I'll show why it was rejected. Show me 205. No, not this one. You give me the main SLP paper. Where's the SLP paper? I'm going to show to your lordships 2 eligibility clauses and why I was rejected. And I'll also show how wrongly I was rejected. That's it. I'll take only 5 minutes to be able to show your lordships this.
Page 6 of the impugned order says that. Okay.
Sorry, not page 6.
Earnest money and delayed approaching of the court.
There is no delay, my lord. I'll show it. So immediately I'll show there is no delay. May I first answer delay, my lord, since your lordships have put it to me. So, my lord, the first date is 7th March 25, when I got an email saying that my bid was technically unsuitable. No reasons given as to why it was technically unsuitable. 7th March 25. Then, my lord, I wrote to them on, my lord, 21st April 25.
To March 25 and you filed repetition in 1st of May.
Correct. That's because, my lord, to the first May 25, my lord, it's not such a great delay, my lord. It's a 35-year contract, my lord.
Can go after 3 years.
I'm sorry. Not 3 years.
It's 8 years also.
My lord, and please consider this. I was never provided the reasons for the rejection until it was provided to me before the division bench. And I want to tell your lordships what those reasons are. If your lordships are still not convinced, of course I'll be out.
Actually, this is not a case for us to.
My lord, I'll be able to show. Please give one opportunity. But the courts have not considered it, my lord. My lord, your lordships have seen both, my lord, with great respect. Neither the single judge or division bench considers any of my objections. It's a 140 crore effect, and I'll just show in 2 minutes to your lordship. If your lordships are not convinced, I'm out. My lord, 2 minutes. That's all. My lord, may I just show the clauses 205, 206, and then show what the reasons are, which I got to know at the stage of the division bench. Please see 205.
What?
Unless your lordships have it, worry. I'll read it. 205 has a clause 16.2 which says eligibility criteria. So that, my lord, says that you need at least 2 years experience, etc. We have that experience. And it also says that date of registration of tender should be minimum 2 years prior to the date of opening of the tender. So 2 years. Your lordships may take it. Next, my lord, this says audited balance sheet of the last 3 financial years have to be provided from the chartered accountant. I have to provide 3 years of chartered accountant balance sheet, my lord. Then, my lord, the next clause of relevance is clause, my lord, 22.15.1, where it says in continuation of 16.2, which is at page 210. I was reading 206, now I'm reading 210.
Yes.
Lord, may I just read this to clause 22.15.1. Technical eligibility for the work as per para, this should be 16.2, not 17.2, this is a typo, shall be satisfied by either the JV in its own name or style or any member having minimum 26% share. At least one member of the JV shall have at least 2 years experience in manufacturing, transportation or logistics and related business. Net worth of the lead partner of the JV shall not be less than 51% of the total net worth eligibility criteria of the tender mentioned at 16.2 above. Arithmetic sum of individual net worth of all the members shall be taken as the JV's net worth to satisfy the requirement. So, my lord, lead member should be 51% of the JV. Now, my lord, please come to the reasons for the rejection. And when your lordships take that up, may I request your lordships also to please keep open, my lords, IA 216544 of 25. Because IA 2164 of 25 has every document answering the objections of the other side, and this is all on the record. Show me page 152.
Yes, sir.
No, first show me.
Yes, sir. Tell us.
Yes, now if your lordships will now come in this very volume that I was reading to your lordships, please come to page 275. 275.
One.
275 your lordships will come out.
Your 2 minutes is over, I thought.
No, my lord, I was just reading the clause. Now, my lord, I'll literally take no time at all, my lord. Unless I show it to your lordships, I won't be able to do it. If I say it, it won't make the same. My lord, 275, my lord, the very last line says, as per condition, audited sheet of balance sheet of last 3 financial years to be submitted. It says so. But bidder has submitted audited balance sheet of lead member for only 2 years and other members for 3 years. So they say, the lead member has not submitted for 3 years. To which, my lord, now please come to IA 216544, which I just mentioned to your lordships, page 156. In fact, if your lordship may come to 152 onwards. Now, just see how, my lord, at best a typographical mistake has been treated as non-compliance. I just want to show it to you. 152, my lord, of this IA 216544.
Yes.
My lord, your lordship, my lord, 152 is the balance sheet for financial year 2021-22, and the bottom to whom it may concern, my lord, mentions assessment year 22-23. So that's absolutely 1 year is there, my lord. Next page is also the same year. Next, my lord, we come to 154 now. This is FY 22-23, and bottom it says assessment year 23-24. No problem. Now the next, my lord, page 155 is again not a problem. If we come to 157, 156, this is financial year 23-24, so 3 years are complied with. And bottom it says assessment year 24-25. But at 157 top, instead of 31st March 24, there's a typo which says 31st March 23. This can't be a reason for saying I have not submitted 3 years balance sheet. I have given 3 years balance sheet. Bottom also says, my lord, 31st March 2024.
150. Can we ask them?
No, let me finish all the 3 points. There are 4 grounds of rejection. Let me deal with all 4 one after. And like I said, I finished one. The other 2 also are finished very quickly. The second point of rejection, my lord, is that which your lordship will find at page 279 of, my lord, the main SLP paper book.
Yeah.
My lord, please come to bottom of 278. This is the power of attorney point. One power of attorney has been submitted. 5 members of JB have authorized Mohammad Erar Khan as lead member, but it is found that except Mohammad Erar Khan, no other member of JB has signed the POA. Hence, POA is not acceptable. So he's saying he does not have the authority to give the bid. Answer to that, my lord, your lordship will again come back to IA 266511, which your lordship will find at page 5 of that IA. This is the document which was submitted. All 5 have signed.
Okay, what's the next point?
So all 5 have signed, page 5 and 6.
Very
Yes, my lord. The next point is they are saying there's a problem with the net worth certificate at page 276. 276. They said that there's no net worth certificate. Answer to which is at 188 of the IA. My lord, 188 of the IA mentions the net worth certificate. It's there.
Right.
And lastly, my lord, it says that that we did not have the experience of 2 years, which I read to a lordship, which is page 268 of the SLP. The answer to which is at page 8 of the IA, where again I have a certificate of 2 years. So I have been non-suited on 4 non-existent grounds. My technical bid rejected, financial bid not even considered, and this is 140 crore lost to the exchange. And I have not been
Done. Done.
These are
All right, you're not inclined. Thank you.
my-
Dismissed. All the next please.
Sorry, I took up a little
No.
time than my 5 minutes.
You're entitled to that. What's wrong?
Lord, sir, I am led by Mr. Taneja.
Not covered by Silpi.
This,
Please, Lord, I beg to appear for the petition, Lord.
It's not covered by Silpi.
Lord, the one important question of law is, Lord, Shilpi doesn't deal with works contract. Works contract, whether it is included in the domain of MSME Act as an issue.
Is anybody appearing?
Yes, but respondent is appearing. I think so. They are also online.
34, 37
Everything is
is
that.
also dismissed, but that's the only question that works
Yes.
contract would apply or not. How do you say works
No,
contract?
my lords, insofar as, my lords, the present matter is concerned, my lords, the admitted position as per the contract of the petitioner itself, it's a
You are
rate
a
contract.
petitioner.
Yes, no, my lords, I am for the respondent here. The petitioner has,
He's
my
saying
lords,
that of course there's all finding award has become final till 37 and review also.
yes, my lords.
Applicability of MSME to works contract in some matter has been raised, I suppose.
Yes, my lords.
In
There is a-
in Lordship
there is
and
one-
in a coordinate bench has issued rule in that matter. We'll just pass a ARADHE matter. My briefing council will just pass on that order sheet arising
No,
from
no,
Bombay High Court.
The Bombay High Court.
No, my lords, there is a Honorable Calcutta High Court order.
Similar matter is pending, we'll post it there.
Yes, no, my lords, my respectful submission is, my lords, even, no, my lords, insofar as I am concerned, my lords, I am not even covered under the work contract. The document, my lords, of the petitioner.
What is the nature of the contract here?
Rate contract, my lords, we kindly see.
Diesel
I will
gensets,
just show one
it's sale of
document.
diesel gensets.
And
Yes, ma'am.
installation. And
Yes,
installation.
Lords, installation
Hardly
being.
installation for the.
Lord, I'll just show. I'll demonstrate it. Lord, I'll demonstrate it. Give me an opportunity.
What
I'll
works
demonstrate it.
contract is that?
I will
The
only,
works contract is a mix of supply and services.
There's nothing like that.
if my
Lord,
lord
can-
will
can
only
you
see.
see
The other case which we saw was
I am supported by Cone Elevator's judgment, which is there by this honorable court itself. Cone Elevator says the predominant test is not the applicable test.
Right.
If it's a mixture of two,
Contract.
yes, please
Lord,
see.
would only see.
Setting up a diesel genset.
My learned friend will bear with me because that's a question posed to me. Now, kindly see not the SLP. Now, please see my scope of work. Page 44.
What is the contract involved in this case you are referring to?
Not in that ARADHE matter.
It merely says leave granted. What's the contract involved?
Page 64 may kindly be seen of the SLP.
This judgment says that works contracts are not covered.
What kind of works contract is this?
Page 64 my
Just-
lords would see.
Get it
And
by
we'll pass on that Bombay High Court judgment as well.
Page 64, my lords, annexure P2 of the SLP. My lords would see at the top, Bharat Sanchar Nigam Limited, rate contract number. So it is an admitted fact, my lords, they themselves document says it's a rate contract.
Ah, that's a sewerage scheme. So you set up a whole sewerage there. And that is very different from that of a contract to hand over a diesel set and then put it
The
there.
diesel set and installation and
Sorry,
Minor
Not
civil
kind
works as well, my
Dismissed.
Give me a minute.
No, I think it's concurrent.
Mr. Khan will just bear with me. Give me a second. I just want to show one document.
Not necessary.
One document, sir. Just one.
Grateful, my lords.
Much obliged.
Obliged, grateful, my lords, grateful.
Next.
To the respondent.
May I please, Your Lordship? Your Lordship, I appear on behalf of appellant. We are being led by learned Solicitor General in this matter.
Every time it's coming and getting adjourned. So many times.
Your Lordship may kindly grant me one.
Well, may I just make one submission, madam?
We thought we'll just clarify the position that you have already said it.
Correct, madam.
That Sri Krishna
They
Commission.
need not be bound by that report. Well, in fact, my lord, the SAT, appellate
Come
tribunal,
tomorrow. We'll clarify that. Please and leave it at that.
grateful.
In a case of a tender, my lord, where the work was initially awarded to us, later a writ was filed, technical evaluation was done. Both of us got 93 marks, equal marks in the technical evaluation.
What happened? Just tell us the facts.
Yes, my lord, this is a contract for operation and maintenance of a power plant. My client was the successful tenderer. Work was awarded to him. The unsuccessful tenderer filed a writ petition. High Court directed the technical consultant to reevaluate the tender. Even in the re-evaluation, both of us got 93 and 93 marks in the technical evaluation, and a difference of, Your Lordship may kindly note, 0.205301 decimal points difference in the financial.
What else can be done?
11,400. No, my lord. If that is correct, then I am out. But the contract does not provide for one the re-eval. They initially challenged the tender terms of the tender. In the course of the hearing, the High Court directed a technical re-evaluation. There were two issues there. They reduced my marks in one point and refused to give me marks in the other. And the difference is minuscule, my lord. And the law on the subject is very
High
clear.
Court said that those additional marks can't be given.
No, the entire work they directed it to be out of the work. But the law on the subject is if there are malafides, favoritism, or undue influence shown on them. None of them is present. No finding of malafides, no finding of any irregularities, an honest tender, evaluation by a third party, namely a technical consultant, has led to the current situation, my lord.
Shows the High
It is not a question of malafide action, not a question of fraud.
High Court order, 1 minute.
Yes, ma'am. And the High Court itself says it's an order, error, page 20, para 48. Thus, on an overall appreciation of the pleadings and the facts, we are of the considered opinion that by preparing the re-evaluation report, the respondent number 1 has corrected its error. No, error is not a ground, my lord, to interfere, but to by a constitutional code in public tenders. The law is so clear on the subject.
When it was granted in June 25, right?
Yes, my lord.
And
January 25, the work was floated, the order, and the work order was placed on us in June 25.
June 25.
Thereafter, a writ was initially tender terms were challenged by a participating tenderer. Then an amendment was sought. Then a re-evaluation was given. And in that re-evaluation, something was done. Therefore, I filed another writ petition, which was both heard together. This would require about 20 minutes of hearing, my lord.
My lord, did you say? Then what happened? You didn't get an interim order here?
No, my lord, your lordship directed notice to be noted. In fact, the owner is also present.
Okay.
My lord, as far as the reduction of 2 marks,
What happened after the High Court judgment?
After the High Court judgment, we filed the SLP, my lord, then your lordship's ordered notice, and then we are continuing with the work.
No, the contract was given in their favor.
The High Court directed them to. We are continuing the work. In fact, last time also, we are He is for the owner.
So you are continuing the work?
Yes, we are continuing the work.
despite absence
So
of
it
the
was
same.
not handed over. Okay, that's it. We were wondering matter might have become infructuous.
No, it does not become infructuous because
Then it's
mobilization and
Then
demobilization.
it is live.
Then it is like mobilization and demobilization takes a little time, my lord. Therefore, we are allowed to.
May I,
Continue the status quo. We will hear them.
may I just,
We'll hear all of you.
Yes, my lord.
my lord, there is only one point I wanted to indicate to my lord's order.
But
As far as reduction of 2 marks is concerned, as far as his client is concerned, he doesn't challenge it. He says 5 marks, which was supposed to be awarded because of a sister concern. He's taking credentials of a sister concern's experience, which is rejected because of the express provisions of the tender. Express provision says you as a
Hair
media.
splitting process is actually not to be done.
Answer is in page 6.
We'll hear you, Santosh.
Please,
We'll hear you. Check it up for hearing. With non-redundant.
Yes.
Yes.
Given that they are in and we are the one.
We'll immediately list it. Early hearing.
An early hearing.
More than a year has gone
Hmm.
and.
Yes, yes.
Or whatever.
Post for early disposal कोई नहीं. कोई आगे वाला.
They are sitting with our
कम
performance.
देंगे public.
No.
कोई Friday में ना.
In the street.
Please maintain status quo till that next date of hearing.
No, may not.
We're not recording. We are saying.
Yes, my lord.
You are
Because-
telling the owner. Yes, 30.
Grateful, my lord.
Yes. Hold it.
Much obliged.
Yes, Mr. Narayana, what is to be done?
Your Lordship, may I?
Who is in possession? Oh, this is this matter. My God, how many times it has come?
Your Lordship, there is a development, Your Lordship. Lordship, I am for the administrator. I was impleaded, Your Lordship, because the administrator had taken over, Your Lordship.
Well, administrator took over.
Yes, Your Lordship.
Took over that mutt.
Yes, Your Lordship. Now, in a separate proceedings, Your Lordship, the order has been vacated and the Mahant has been restored, Your Lordship, which is pending before this court, Your Lordship. Please see.
So what's the implication of that?
I will not be able to represent the Mahant.
Oh, okay.
My authorization as.
Okay, you can't appear is what you say.
Yes, Your Lordship.
Earlier, another council was appearing for the Mahant.
I see. That was restored, is it?
By way of an interim order.
Matter is coming up on 6th.
What happens? I think some matter is pending. In second appeal, what happened?
No, second appeal, That is in respect of a suit that was
Doesn't matter. What happened to that second appeal is what you're saying. That second appeal is pending. That's the second suit
No, that is
seeking an injunction restraining the defendants
I'm told that the
from converting the land and using the land for commercial purpose. There's an injunction. So that's pending. It's
second appeal was allowed. I'm told.
allowed, is it?
Yes.
Second appeal was allowed.
Ultimately, the question is
You are the defendant. You are the defendant in that suit.
yes.
That was that second appeal is over. You lost an injunction then. You lost the injunction then. And if you had lost the injunction, then this repetition
That is for
is against section 82 notice.
State few facts, Miller.
This is basically writ petition 82 notice.
This is a writ petition issuing notices under section 82 of the Act. Miller, there was an earlier suit that was filed in 1971.
Concurrent against you.
No. The issue, Miller, was not decided in the correct manner is my submission for this reason. Miller,
Section 82 notice issued to you. You challenged it by way of anyway. What do you want us to do? He is not there to contest.
Lordships can have it on some other day. I will write. I'm only on the.
Now the Mathadipati has been restored via an interim order. The main matter is pending.
So what do you want us to do? Put it up on
My lord,
grant leave or what do you want us to do? It keeps coming regularly.
Can grant the leave.
What is that grant leave again, matter? Section 82 notice.
Can have it out
4 weeks. के बाद लगा. In the meanwhile, see somebody represents it.
my lord, time for the
6.
speech. We have been told to hold our hands off the mud now by way of.
Okay. We'll just hear him and decide, that's all. Who will be contesting? Or you have to contest the matter.
My lord, because it is the mud who is now under the control of the.
Section 82 notice was issued by whom?
by the administrative officer of the MUD.
At the time, because he was acting as the Mahant, because the state had taken on. Now the Mathadipati has been restored by way of an
82 notice is for
Issued by the
Whole of
administrative
encroachment.
officer of the MUD, saying that by virtue of section 82, the leases were terminated. What happened was leases were given 150 years back. They claim that they have been, Shashwata Patta was granted by the then Mahant before enactment of any of the Endowments Act. And they continued and there were alienation of the property also in favor of third parties. For the first time in 1971, MUD files a suit for the purpose of recovery of the property. That suit was dismissed, affirmed an appeal, and also in the
What
second.
will happen if we dismiss this application?
Then now, though there is no subsisting lease as on the date of commencement of the Act by way of section 82 of the Act, they say our leases were cancelled. We are not even lessees. We have never paid rents to them. So the question, fundamental question that needs to be decided
Meanwhile, no, if the notice, you merely challenge the notice, the proceedings will go on.
On the fundamental question,
Proceeding will go on. You
there is
raise
no
all the
other
objections.
the Act doesn't contemplate any proceeding.
Only remove.
By a declaration, they says all the agricultural lands by or
Okay, Prerana, you will have to take instructions and come. We will hear you. We will hear you. After 3 weeks, take instructions and come. We will hear you. There won't be any other contesting party.
No, my lord, then I will contact the MUD.
Yes, take instructions and come. List after 4 weeks for disposal.
Obliged.
One-time spectrum charges. Did I appear in this matter?
Lordships have
One of
appeared.
the tag matters,
But in the Aircel matter, Lordships were pleased to appear now.
1.6.
Then we will say not before me.
Please.
Not before us.
Because I'm appearing for this number.
Lordship, on item 30,
Earlier,
compliance report has filed, but I have received it recently. There are some compliances which I have already done, and one
on an NGO.
permission is to be received to me on 20th of this.
Because this is a matter pertaining to the pollution.
I agree.
There is a
8 crores as an interim order.
yes, my lord.
Emission in excess of sulfur.
Yes, it's a thermal power station in the city of Chandrapur, which is highly polluted. Now, the respondent number one is Green Tribunal, and Green Tribunal had given a very scathing order with certain directions for compliance. Now, the petitioner herein had approached this honorable court wherein the notice was issued.
What happens to the joint committee?
Filed its compliance report, which I have received late. Now we have sought permission for SO2 approval, and the date for that permission is on 20th of this month, Lordship. I am just seeking 2 weeks time so that I can find a proper reply to the compliance.
You are asked to deposit 5 out of 8 crores. Have you done that?
Lordship, interim amount is paid and it is filed before the EDU. It is
Okay, come back, come file your counter. We'll hear you.
Yes, Your Lordship. I just require 2 weeks time.
2 weeks post after 2 weeks.
Just
Maybe filed in, maybe come after last month.
Post after 2 weeks. Don't take more time. Come after 2 weeks.
Please, minutes.
Lordship, I am appearing for the petitioner here.
There are 2 SLPs. One is by private parties, one is by the board. This matter concerns TET marks, grace marks were to be given, my lord. Grace marks.
Lordship, I am for the petitioner.
He is just wait and
Lordship, I am for the petitioner.
I am also for the petitioner.
when will all of you stop talking when the petitioner opens up? Yes, tell us.
I'm
Lordship, Mr.
33.
Gupta is leading me. He is held up for another court.
Can I just explain the facts? He's in 33.1. I'm in 33. Can I
I am
just
the
explain?
board.
Okay. We will hear you. We will hear you. Post for final disposal. We'll hear you.
Very well.
2014 TET, most of them have become OAs for any employment. This has been every time somehow or the other. So for the last 12 years now, they're waiting.
They have come out with a fresh notification.
Can I start for the main petitioner? Board is for 33.1.
They have started new.
My friend can start, It's a very short issue.
Not at page 51. High Court has
We'll
reported
post
it has been complied with.
we'll post it for a disposal.
Very well.
Final disposal on an arms.
May I make just one request, madam? ये नंबर क्या है?
इसको भी पास सही चीज पीछे
There's one peculiar fact, if I can point out, which may be 1 second, please. But the adjudication may not be required for this reason, that the OMR sheets where these attempts were made, later on CBI has filed a report that these OMR sheets are not available with anyone. So therefore, the marks that had to be given are to be on the basis of these OMR sheets filled by each of these candidates.
Lordship,
1 second, please.
No, the board is the authority who has the way. We know what is there.
He can
All
argue.
right, after 2 weeks.
Very well.
After 2 weeks. After 2 weeks.
Very well.
There's only one thing.
34.
Fix it.
Yes, we'll fix a date. Yes.
There's some IAS for impeachment.
We'll allow it.
Grateful.
Lordship, IAs, they are not. We have to know.
Get them in.
Just exception, Lordship made a call.
Yes. Next.
Grateful.
So, my lord, now the inquiry has come to an end. Exonerated on all charges. Now the time has come for me to resume duty as a senior civil judge. Every charge I'm exonerated.
Incorrect, sir. Incorrect. Charge 1, you are found.
Every charge I'm exonerated.
Charge 1, you are found.
I'll argue every charge. Every single charge.
Charge number 1.
Now the only thing he wants to do, he wants to start the inquiry afresh. And there's a judgment of the Supreme Court on his rule, Gujarat.
Anyway, neither here nor there, this kind of posturing, you will have to tell us the case and then start.
Yes, my lord. Can you take my...
What happened? Charge, resignation.
Just a note.
Second inquiry, what happened? We'll ask you.
Lordship, second inquiry was
Let your lordship stayed. De novo inquiry is stayed.
De novo inquiry was to start, my lord. She took time and therefore it could not.
No, your lordship stayed it. There's an order of the court.
Before the order of stay.
We'll just see if we can be.
Absolutely.
We are raising a little early today. Just to give us. इसको डाल देना. Next week लगा देना. We'll keep it on board. We'll take it up for next Tuesday.
Can you lordship?
Next Tuesday. I on board कर लो.
Sir, can you keep it on 18th, please?
Is that okay? 18th. 18th.
Grateful.
Note kar lena 18th. 18th is what day?
It's Wednesday.
It can't be on Wednesday. Is that here, but Monday, Tuesday, or
And after the short break, man.
there is a short break.
End of the month.
By Tuesday, Friday or Monday, laga.
24th, please, madam.
Has the latest position be brought on record by way of an affidavit or something?
We'll do that. We'll do that.
And do that, huh? Or else how would we know?
24th, my lord.
Further developments are not brought on.
No, for the.
I've done it, my lord. I've brought it on.
File in short affidavit.
Submitted an application for resignation, which is withdrawn later on.
We'll see that.
24th?
Yes.
Grateful.
Next.
My lord, a very short point is involved in this matter, whether the state of Tamil Nadu can put restrictions beyond its law.
Yes, we've heard it.
My lord, yes. Your lordships have heard me, lord.
Then what? Once the report has come, we will have a look at the report and then we will decide the case.
Should ask the AST to find out what is the regime. So that
My lord, the learned is
Mr. Nataraj is here.
My lord, Mr. Nataraj is leading me. My lord,
No, we have not seen the last time we were, because this came for the first time before us, we were unaware of it.
My lord.
I've gone through those orders.
My lord.
Now we'll have to check about
should we take it after
their right.
Respond if he has to, he will make
So
a.
is anybody, you are filing objections to the report?
We have filed. It may not have come on record.
It has gone against them.
We have filed. Because according to us, it has to be an all India issue of all the states which have ordered the seat. Can't be like that. There are two judgments of the Supreme Court which will not decry this practice also, on which we will not say.
Lord, the matter has to be hard.
and
My lord.
to
It can't take more than 15-20 minutes, my lord. Please.
That's all right.
My lord, my season is going away, my lord.
Union of India has
Astona.
the report submitted by the committee constituted by your office.
All right.
Friday, your lordship.
कुछ डेट दे देना.
Not a Friday, man.
Tuesday can't be on a Friday. कोई Tuesday लगा देना. Next.
Much obliged.
We'll give a date.
Lords, in item 36, my lords, this matter was mentioned.
Praying for short accommodation, your lordship. Your lordship.
Lordships are rising today. The issue is whether
Your lordship,
we have
for a short
qualification,
accommodation, your lordship.
whether we have the qualification of a riverine dredging.
Oh, this is riverine thing.
Yes. That's a very short matter. Lordships are rising early today, I believe.
Yes.
And therefore, lords can take it up tomorrow. 10 minutes maximum, we are going to argue the matter and finish it off. We only have to show two pages. If your lordship are ready, I can show it right now.
Okay. We'll give it.
Your lordship.
Lord, this was mentioned.
Jaldi de dena.
This was mentioned, my lord.
They give an earlier date.
There is a time bound.
We'll give it here in this month only. Give a date on that. इसी महीने में अगर होगा तो दे देना. ठीक है?
My learned friend has also rushed back from.
That's your breath. It's a very
short.
We are raising a little early today. There's some meeting.
They're working the contract. Despite my
Date दे देना.
with marine dredging.
Next.
Will be tomorrow.
Not tomorrow. Give a date.
The main matter should be listed.
Maninder Singh, we got your written submission. Have you come? Have you filed your written submission?
To file.
Yes, one second.
You wanted yours, no? You are the only person who can give us a different perspective.
I'm the only one who's having a different.
Yes.
The main matter in 36 we also listed.
Yes, both matters.
Not just the IA, my lord. The IA is for stay.
You are listing the entire matter for
Very
this
good.
present.
Very good.
Just give me time and 5 minutes.
Yeah. Independence. 2 weeks.
Receive the report of the amicus. I have received.
Yes. Go through that and then you show us the different perspective in that. Because we need to balance.
What wanted, my lord, the solution is balancing.
That's right. You can give a different perspective. Thank you.
My lord, could you give a specific date, my lord?
38.
Let's take it next week, my lords.
We'll do it. Next, 38.
38 minutes may take it next week, my lords.
What is this about?
Lord, this is a matter where the tribal land has been acquired by BCCL for last 40 years, my lord. They are commercially exploiting.
Oh, the sun.
Yes, my lord. So, my lords, pose them a query on after hearing me, my lords, whether they are willing to acquire as per present law or release the land, my lords. So they have to come back with that instruction, my lord.
Who is appearing?
Mr. Das, Mr. Anupam Das was appearing. My lords can take it next week. My lords.
Wait. Next. Great village.
Please, my lord. My lords, this is a short matter. If my lords are inclined to hear it, or my lords can have it next week, since my lord said, my lords are right.
What is it about?
My lords, this is regarding calculation of pensionary benefits. So,
All service matters.
service and nothing pressing us.
Okay, leave granted. Leave granted, we'll hear the matter. Hearing expedited.
They're all pensioners waiting for the revised pension. Your Lordship may visit next week.
ठीक है दे देना मार्च अप्रैल में दे देना. All right, we'll give you. Next 40.
May
I please note? I'm a personal beneficiary of my Lord Justice Narasimha proposing a win-win solution. So I have a win-win solution. It can be finished off today.
What is this?
This is a matter where by way of the impugned order, the single judge's decision quashing all departmental proceedings against me was set aside. There was an earlier order by the respondents where they had given me the punishment of reducing 3 consecutive increments. Your Lordship may just restore that and set aside the impugned order as well as the single judge's order.
Lordship,
That's a win-win solution because they themselves maintain that.
I am led by Mr. Joydeep Majumdar. He is unwell. I had requested 1 week's accommodation may be given. We had informed the petitioner yesterday evening.
But have you heard him? That suggestion is a good suggestion. Just take instructions on that.
I will do that.
We can dispose it off on that basis itself.
May I just,
come on Friday.
May I just show your Lordships?
No, come on Friday. Let him take instructions.
The order is on page 60. Page 60 of the SLP paperwork can be restored. And both the single judge as well as the division bench decisions can be set aside.
Correct.
Monday. Right. I'm very grateful, Miller.
Yes.
Item 41.
41 is of a similar nature. There are
what?
2 SLPs, one filed under 37, where I have filed a 37 before High Court, the other, where the other side filed a 37. In my 37, the High Court observes the award is a good award, nothing to be interfered with. In the other one, it says it's unintelligible. They also say the award is unintelligible. We say now that it can be either completely unintelligible or it can be, one can be good and it cannot be both ways. So, my lords, I would suggest that the matter requires to be sent for a fresh arbitration and the High Court holds it unintelligible but does not pass the consequential order of referring it for an arbitration. So, my lords, what I am submitting for my lord's consideration is
send it to a fresh arbitration.
Let it go to a retired judge of this honorable court. But my lords, we want it now in Delhi, not in Ahmedabad, because this is 25 years in Ahmedabad, this matter. The case pertains back to
Mr. Balbir Singh, my lord, is on his legs, my lord, currently. My lord. May I request for next week, my lord, we have something to say on this, my lord. This matter should be argued, my lord. My lord, we have clear instruction, we don't want to go to arbitration. 20 years, my lord, arbitration is going on, my lord. My lord, now,
my lord, the High
there
Court.
37
Both of you are saying it's unintelligible. Both of you
no, my lord,
saying that the
award is therefore, my lord, the order has to be seen, my lord. That was their 37. Their 37, my lord, they were praying for announcement of the award. So, my lord, 37, their 37 cause them was dismissed.
Both 34s are dismissed.
And my lord, my 37
is allowed. I think you better take instructions about appointment of a new arbitrator. You take instructions. Come tomorrow.
Lordship may have it next Tuesday, my lord.
Friday.
Very well, my lords. Grateful, my lords.
Well, this is a case of child care leave, Malats. We have filed a written submissions also.
Child?
Written submissions, Malats. On last date of hearing, I was directed to file written submissions, Malats. Very small issues, Malats.
Again a service matter.
Malats, but in this matter, Malats, I'm working as a professor, Malats. And I was denied the Malats.
Child care leave.
Please, Malats.
Right.
Malats, then the letter issued by the commissioner is contrary to the
file your written submissions.
We have filed, Malats.
We'll have to give a date. It's going to be there, date. We'll hear you.
Please, Malats.
Obliged.
Obliged.
Yes.
My lords, pursuant to my lord's last order of 10th of February, my lords had indicated that in this Jharkhand police matters, my lords, with regard to those out of syllabus questions and defective questions, to give a detailed affidavit as to whether we had attempted all of them. My lords, we have given the booklet number and the number of those very same questions, my lords.
Attempt has happened.
Please, my lords.
You have attempted those questions.
We have attempted all those questions, my lords. We have also given the booklet number, my lords, and the number of marks by which we have missed being qualified. Even now, my lords, 1,145 posts are still available, my lords, because the advertised vacancies was for...
Lordship, if your lordships may recall from the previous hearing, these are the petitioners who had withdrawn their writ petition.
No,
The matter-
but then they have attempted those questions, is what they said.
Please.
Your lordships, but at the end of the day,
They asked you to find out, no?
your lordship.
Better, my lords.
But if they have attempted the
verify.
question, then they should be entitled to, isn't it?
Your lordship, but I may only clarify the adjudication, how it has transpired in their case, your lordship. They withdraw their writ petition. That order has attained finality. There is no adjudication in their favor. They file an impleadment application in a connected special leave petition. Impleadment is allowed. None of their submissions are noted. The order of the single judge is not set aside. There is no consideration vis-a-vis them in the order of this honorable court. In
If you can, on the
my lords, I join issue on that.
Sending that matter back and for them to file another writ petition. If you can take instructions and file an affidavit to that statement, we might even dismiss it, but we will consider them instead of sending them back all over again.
With my lord's permission, my lords, I beg to submit, my lords, that the factual narrative given by the learned counsel is absolutely false. Only qua the first thing, my lords, that yes, there was a writ petition, my lords. The lead writ petition, my lords, had been already dismissed.
Your case was not. You file a counter affidavit to that. On that basis, if you can dispose it off here itself, it's good enough.
Grateful, my
Or else if they don't have anything on merits, we'll dismiss it. Because
I'll do that.
by what time you'll file?
Your lordship may give it
3 weeks will give you.
3 weeks.
Learned counsel for the respondent shall file a detailed counter affidavit to the additional affidavit you file.
Please, my lords, the affidavit in support of this SLP.
As well as the additional
affidavit in support of the SLP, my lords. This is dated 18th of February 2026, my lords.
26. Okay.
My lords, may just bear in mind that the impugned judgment, my lords, categorizes the petition.
Remember that
two parts.
You told us that.
Yes, my lords. One was, my lords, those who had already given an undertaking that they do not want the out of syllabus questions to be considered. We were not under that, my lords. We had actually given the entire gamut. That is why my lords had indicated that you kindly put it on affidavit. Grateful, my lords.
Your lordships, if I may only clarify that if the original petitioners, I'll file my reply.
File, we'll see.
Oh, I'm obliged.
Grateful, my lords. Deeply obliged, my lords.
Lords.
It doesn't reach, Lord. It's been on the last 4 occasions. The first occasion, the other side took a passover. Then it didn't reach. Thereafter, whoever is the standing counsel for the state of Jharkhand, Lords.
Excuse me. Somebody is raising his hand on the screen.
I don't know. You should speak up. Thank you.
Kumar Anurag.
Bullets, I appear for the state. Bullets may fix it tomorrow, Bullets. I have no difficulty, Bullets. I'll be there.
I filed my written submissions, my lords.
I have no difficulty, Bullets.
Would your lordship fix some time?
No difficulty. Grateful, Lordship.
Come tomorrow, will. Yes, come a number of times in the night.
Lordship, I am the intervener in this case. The case is fully covered by the rules which have not been annexed either by the petitioner or by the respondent. I have annexed them as Annexure 1 and 2. Your Lordship may permit, I'll just go through the rule.
We are all, Lord, above 80 years of age, above 80 years. And out of 393, Lord, 165 have already died in this during this litigation. Out of 393, 165 have already died. And they are really wanting to go behind Nakara. They say even Nakara is wrongly decided.
I'll have to answer all these
Even
questions.
DS Nakara, they are wanting to say
We'll
wrongly
answer all
decided. I'm
these
only
Fully
requesting, Lord,
covered by
it
the
can't be taken
rules
up.
only.
Nothing is fully covered, sir.
Simultaneously, we can hear. 8 people
There's
are
a challenge to a validating legislation. How is it fully
People
covered?
are talking simultaneously.
Validating legislation which is trying to upturn judgments of the Supreme Court.
That's all right.
Have it on some other
Have
day.
it next week, Lord. We are actually
not
with
next
all
week, not
of
next
us,
week.
Lord, who are 79.
Not
are
next week,
getting
because
80 are
there
not
are
getting
diabetes
it.
matter coming up. We just can't throw dates like this. Please have some convenient date.
Yes.
Short date is my only request, not otherwise a lot of more
We'll give a
details
date.
will die.
We'll give a date. Leave it at that. Next. Please kill me. अपना stamp पड़ गया है.
Lords, my senior is appearing through VC.
Well, we are being, sorry, Manoj, we are being led by Mr. Gaurav Agarwal, Manoj. Lordship could have it tomorrow, day after tomorrow. There is some urgency in this matter. This is regarding Manoj SARFAESI actions being not, the SARFAESI provision not being implemented in the attached state of Parliament.
We'll have it next week, next Monday.
Monday, very,
On this matters, we'll have it next Monday.
I'm very grateful. I'm very grateful.
47.
May I please, my lords? One of the 47, my lords, this is an 11.6 application, my lords, which was, my lords, the agreement provides, my lords, one arbitrator to be appointed by each of the parties, and the MD has to be the sitting arbitrator, my lords. My lords, we filed in 11.6. We proposed Justice Kurian Joseph of this Honorable Court as an arbitrator. They didn't agree to it. We filed 11.6, my lords. The High Court says no 11.6. Rather, the matter has to be referred to some Madhya Pradesh Adhiniyam under which the arbitration will take place, my lords.
That's part of the statute is there.
Yes, my lords. But my submission is, my lords, our submission is the agreement specifically provides that the rules of arbitration of International Center for Alternative Dispute Resolution, New Delhi, my lords, which have now been overtaken by, my lords, this Act of 2019. They will apply, my lords. Those rules have been framed, my lords, under Arbitration Act. There's a specific provision. There is a specific.
And they don't define then what will happen. That's the question. What happens is they say we have a statutory power.
My lords, I am appearing for respondent. My lords, I am seeking 4 weeks time to file my counter. My lords, we have just entered appearance.
What happened? We hear you.
Yes, ma'am.
He will have the remaining matters on Monday.
My lords, I need some time to file my counter.
All matters will come on Monday.
Even the post
everything will come on Monday.
Item number.
Tuesday. Sorry, we meant Tuesday. All matters. Whatever. Well, if you don't.
Lordship, item number 59, my lords. Contempt matter was listed in the High Court today, and it is kept day after tomorrow because there is
59.
Item 59, my lords.
Take some time there. What can be done? Monday, next Tuesday. All matters will come on Tuesday. What is that? Fresh matter. Fresh matter. Fresh or after notice? Tomorrow.
Well, that's item 55. Item 55, can we have it Tuesday week?
Week will not be a problem. We have to get up a little early, sorry. We have to get up a little early today for a committee meeting. Whatever, all of you agree, give a date.
So which date in